very top of the case where it says New Hampshire Supreme Court. Um, However, in law school, you will have cases where they are from different state Supreme Courts, right? So, like, if you're taking and you're going to school in North Carolina, for example, you're not just going to read North Carolina cases. If you're going to school in Illinois, you're not just going to read Illinois cases because your textbooks will be national textbooks that read various cases throughout the country. However, one thing that is important to know is that once you're actually practicing, you will be focusing on cases based in whatever jurisdiction you are practicing in. But it's still important for us to orient ourselves and have an idea of like where we're at. Another really important thing to look at is the year the case was decided. The reason that we want to know what year the case was decided is one, there may be archaic language that they are using that we're kind of like, what the hell does this mean? Two, there sometimes will be cases that will overturn or, you know, essentially change the law for us. And so it's sometimes what will happen in your case books is they will have you start with a case that's literally from like 1823 that gives you like a very foundational perspective. And then you'll read a case from like 1912 that, builds upon whatever it was that we were discussing in the earlier case. Then you'll have another case from the 1950s, then another case from the 1980s, and each subsequent case will build on from other aspects of your practice. Does that make sense to everybody?
Yes.
Okay. Just turning my do not disturb on. Okay, perfect. So we are this particular case. Does anyone want to discuss what subject you think this case falls into? Did anyone get a chance to read the case before class? I know I sent it out kind of last minute. Anybody want to take any guesses? Okay, somebody said contracts. Anybody else? Okay, another person said contracts. Good. Yes, subject is in like contracts, torts, civil procedure, evidence, things like that. So yes, this is a contracts case. Does anybody want to chime in and give me some context on why they came to that conclusion, how they came to that conclusion, what facts brought them to that conclusion? No one. That's okay. So,
I can say something.
oh, okay. Go ahead, Riley.
Oh, sorry. I was just gonna say, kind of because there was um a like subject matter that was supposed to be performed or someone was gaining a service from somebody else, and then just like the conversation between the two parties kind of eluded.
Yeah, good. Um, and someone else pointed out too, right? It says that a breach of an alleged warranty, right? Now, there are different types of warranties. You will learn about warranties as well in torts, but this is still a good context clue, right? You will not get cases usually that say like the issue that arises, right? This issue arises from the law of civil procedure or evidence, right? So we have to use context clues. But there are a lot of context clues in nearly all cases that will help us point towards what type of case this is and what subject it would fall into. Also keep in mind that obviously in law school, right, you're going to be opening your textbook for torts, so you're going to know that this is a torts case or a contracts case or a civil procedure case, things like that. How many of you are taking contracts in your first semester of law school? Different schools do it differently. Okay, Amber, Rachel, Riley. Okay, a lot of you are. So like my school, we do contracts, or the school I went to, we did contracts second semester, but I know that it is a pretty common class to have first semester, which is part of the reason why I picked it. I also think like every single one of us has come into contact with a contract in our life, right? How many times have you downloaded an app and you fill out, you consent to terms of services, right? How many of you have signed a lease? How many of you have done all of these different types of things? Does that make sense? So this is why I picked this case in particular. This also, some cases you read will legitimately be like 30 pages long, which we do not want, right? We do not want in this particular situation. So it's really helpful if we are able to essentially read a case that's only 4 pages that we can work through together. Okay, let me stop sharing my screen. Now I am going to pull up a PowerPoint where we're just going to give an overview of what the hell a case brief is, and then we'll go through the case together and we will essentially we will brief it together. So let me pull this up. Okay, where did you guys go? Okay, can everybody see this? Yes. Wonderful. Okay. This is the case, or this is the section that we are going to focus on reading and briefing. So, why you need to brief a case. It forces you to understand what the hell is going on before class, and it gives you something to reference when you are cold called. Another thing that's really helpful about briefing cases is that you are able to understand, you're able to then basically copy and paste it into your outline, right? I also think that for a lot of people, just having paragraphs upon paragraphs upon paragraphs of information makes it A, really difficult for them to follow their own notes, but also makes it difficult for anyone else to look at their notes, right? So there will be times in classes where, like, you're sick, your friend's sick, someone has to, cover something for someone. And the ability to be able to send someone your notes in an organized fashion that gives very short blurbs about things is really important. Another thing that we do a lot, not only in law school, but also as attorneys, is we synthesize information. We take really big, complex ideas and we make it as simple as possible. So, forcing yourself to sit down with cases that sometimes will be upwards of 20 pages and making them and summarizing them into very short, simple sentences, not only is a really good skill for you to have in law school, but also something that will be able to translate really, really well as you go into practice. These are the five traditional parts of a brief. Now, what I will say is you may come to the conclusion or come to the realization that certain ways of briefing things is better for you than other ways, right? I personally really like to do a table, which I will show you all. Other people just put sentences next to the words facts, issue, rule, analysis, conclusion. Other people prefer doing something that's a little bit more visual. The other thing is you don't always need all five of these components, right? Because sometimes what ends up happening is the rule is really similar to the conclusion, or the rule is really similar to the analysis. Um, but I think when you're starting law school, especially those first few weeks, it's really important to write all of these components down for each case you review because it will then allow you to be able to answer the questions your professor may ask you during a cold call. So, the facts are essentially what happened. When I am putting the facts together for my briefs, I do bullet points. So I'll say, like, Sam went to the grocery store. When he was at the grocery store, he slipped and fell. When he slipped and fell, he broke his wrist. No one at the grocery store knew that there was liquid on the ground. So that's the type of facts I will generally put in my brief. The issue, the issue is whatever the legal question is, right? And some cases will actually have multiple legal questions, which makes it really difficult to do your job in these situations. However, the phrase to look for when you are trying to find the issue is the issue is whether, right? Or we're looking for something that says, the court is considering. Those phrases generally, obviously, if it says the issue is whether, that's like putting it on a silver platter. A lot of the cases when you first start law school will be very, very straightforward as it pertains to the issue. The issue eventually will become more abstract. One thing I will flag is within your textbooks, just like in undergrad, you'll generally have like a paragraph or two of information explaining the concept, right? So let's say you're talking about the basics of a contract, right? They will give you a very, very, very straightforward um analysis or thought process on what a offer is, right? Then you will read the case. So then obviously if you're reading the facts or whatever it is, the like blurb the textbook gives you, then you go to read the case and they're talking about what an offer is, what an offer to enter a contract is, right? The issue is probably going to have something to do with an offer, right? Whereas in real practice, and as you start to do more legal research and things like that, the issue can be a bit more abstract, and the issue they want you to focus on can be a bit more abstract. So it's important to use context clues even within, the syllabus of like, okay, what's the heading for today's class, right? Or within the textbook of like, okay, what is the textbook talking about? Because that will give you the ability to then review and analyze those concepts. The rule is essentially a sentence that says whatever the most important part of the case is. And usually the rule is answering the question of the issue or it is giving some more context, right? So for example, if let's say the issue is like, was a contract formed, right? What the rule might be is that a contract requires offer, acceptance, and consideration. Those are the three basic elements of a basic contract, right? Offer, acceptance, consideration. Offer is someone offering to do something for someone else. Acceptance, right, is someone saying, I accept the terms of that contract. Consideration is something exchanged, right? So the thing exchanged generally is going to be money, right? But sometimes it can be, an inconvenience to somebody else, and that would be the exchange. For the analysis, right? It's why did the court come to the conclusion it did, and why did the court extrapolate the rule that it did, right? So it very much so will give you context on like, okay, the thing the court was looking for was A, B, C, and D. That's what you'll put in the analysis section. And then your conclusion, right? It's what was the court's decision. Now, I will say that one of the harder parts about briefing the cases to start is the conclusion usually is kind of abstract, right? So in the case we're going to talk about today, they will send it back for a new trial. Now, this is oftentimes, right, abstract, and until you've really gotten through civil procedure, it's hard to understand what remand means, what a new trial means, right? So to start for the conclusion, I really want you to focus on like, did whoever filed the appeal win? Right? And why? And that's the basis of the conclusion that you want to focus on when we are doing our brief to start. Does this make sense to everyone? Does everyone have any questions about the five parts of the brief? Thumbs up. How many of you have briefed a case before? I probably should have asked this at the beginning. No one? Riley has. Okay. Okay, incredible. Next slide. How to read a case. Okay, we talked about this a little bit at the beginning, right? We're going to read the name and the year of the case. It's going to give us a context, it's going to orient us, it's going to help us know where we are. Um, then we're going to skim the first and last paragraph to have a better understanding of what's going on. Then you're going to read the case, and then you're going to write your brief. Okay, so I include read again and highlight strategically and read without highlighting because I do think that when we're first reading a case, especially when you first start, I was guilty of this too. I would highlight like every single sentence, every single paragraph. So I had literally when I'd go back and be like, I have no idea what the fuck's going on. So if you have the self-control to not be a lunatic like me and highlight every single paragraph and every single sentence, great, highlight away. And this is the way that you are going to read cases for the first 2 weeks of class is going to be very slow, meticulous, thoughtful. And then as you get further into the semester, you will be able to pick up the pace because you'll have a much better idea of what you're doing. Okay, I love a highlighting coding, especially when you are first starting law school. The reason that this is helpful is because it allows you then, when a professor cold calls you, to find where you found your information. Obviously, if you're renting your books, if you're not allowed to draw on your books, if you're not allowed to highlight all of these things, that's totally fine. But if you are someone who likes to highlight, I would just assign a specific color to everything. So, for example, here I have facts as yellow, blue is the issue, pink is the ruler holding, and then the green is the reasoning, right? I use this color coding for every single brief to this day. When I read cases within the legal research world, I will literally still use this color coding because to me, when I see the color yellow, it is a fact. Does that make sense to everybody? If I say Westlaw, do people know what that is?
Yeah.
Okay. I will just give like a very quick like note on that. So Westlaw and LexisNexis are the two major legal research databases. Okay, most of your schools will give you access to both Lexis and Westlaw. Most law firms prefer Westlaw, so once you are practicing, you will likely only use Westlaw. Essentially, what it is like the encyclopedia for legal research. It is every case within a certain amount of time. It is basically like every case ever from every jurisdiction, right? It has like every statute. It has uh we talked about this a little bit yesterday, but legal journals are written by legal scholars, and they oftentimes analyze case law or analyze a case or some sort of social issue from the perspective of the law. Sometimes it's a student that is writing the legal journal article. Other times it's like professors, right? You also can access all of those on Westlaw and Lexis. Most law students prefer Lexis. It's a little bit more modern for an interface, whereas Westlaw is a little bit more archaic as an interface. However, I love Westlaw, and I think that like one of the best parts about Westlaw also is their attorney reference program, where you can basically reach out to someone where their sole job, their entire job is legal research. You can ask them a question, they can help you find what you're looking for, and that I think has become a really good strategy that I used in law school that I now carry with me in my practice. Okay, let's talk about the facts, right? I only want you to write what matters. Include who, what, when, where, and why. I do not need 17,000 paragraphs about it. I don't need you typing out every single paragraph. You're going to have your textbook in front of you. Whether it's a digital textbook, whether it's a physical textbook, you will have it in front of you. And that's why I think that bullet points for the facts is super helpful, right? Because then it's going to be way easier to skim and to find specifications that you need in order to find the information you need when you are getting a cold call. So even here, right, you can even put this into bullet points. The other thing I will say with facts is I do want you for the first few weeks to really push yourself to put it in your own words if you can, rather than copying and pasting exactly what the textbook says. Okay, then the issue, right? The issue is the legal question. Like we talked about earlier, you usually will find it within a case. It'll say the issue is whether, it'll say the court is considering, right? Something like that. And you can usually put it in a question. Now, you could also write it as a statement and say the issue is whether, fill in whatever the end sentence is or the ever the end portion is, if that makes sense. But at the end of the day, right, you can phrase it however you want. I generally will say the issue is whether. Some students prefer to put it in a question. It doesn't really matter as long as you have an idea of like, what is the focus of this case? What are they trying to have me take away from this case? What question should I be able to answer after reading this case? Okay, then we have the rule and the holding, right? The general legal principle for the rule is like, what is the one sentence I can take away from this and apply to other situations, right? And here's that example I talked about earlier. A contract requires offer, acceptance, consideration, right? Whereas the holding is what is the outcome in this specific circumstance, right? And here it's that, like, Bob is liable for breach because he caused all three elements, right? Or all three elements were met. Holdings generally, the court will start that portion of it saying like, our reasoning for this decision or, the given the facts, yada, yada, yada. Or the court in holding, comma, right? There will be buzzwords that will help clue you into things. And I think that can be a really helpful tool, especially as you're starting this process, because it can be really, really overwhelming to start. Then we have the analysis. Why did they come to the conclusion they came to, right? And why is that significant to us? And how does it apply to the case? This is the part where most of the time people are just taking a highlighter and coloring in the entire fucking page, right? Or the entire paragraph. But really, what we want to see is like, why did they make that decision? Why did they come to that conclusion? And what facts did they pull from the case to come to that conclusion? Your brief is meant for a tool. It is meant to help you, right? It is for you. So at the end of the day, right, I recommend following this as like an overview. This is what I recommend. This is what works for me. And this is what most of your schools will teach you as well, right? But you will quickly realize that in some classes, you don't need a full brief, right? You need the facts, you need the rule, and maybe an issue statement, right? And depending on the class and depending on your level of understanding too, that will also impact how you are doing this. Also, please keep in mind that your briefs will get better with time. You will become better at narrowing things down and understanding things. I promise you, I promise you, I promise you, I promise you, it will get easier. Okay, let me stop sharing quick. Let me pause the recording. Okay, so let me share my screen. Okay, exciting times. Here we go. This is my Word document. What I do is I insert a table and I will go down like this. I will say rule, or sorry, I already am making mistakes, guys. That's not a good sign. I will say facts, rule, issue, analysis, conclusion. Then I drag this little tab over. I prefer to bold this. Okay. Then I'm going to come over to my case. So we're going to read it. We're going to follow my coding, right? So we're going to do yellow is going to be facts. Um, then we'll do blue for the issue. Then we'll do pink for like the holding or the reasoning. And then we'll do green for like anything else we want to talk about. So, okay. Defendant's motion for a non-suit and for directed verdict on the on the an account and a subject were denied and the defendant accepted. So basically what this means here, right, is that this is giving us an overview of what the hell happened. Does that make sense? So like I said in my overview, right, you want to read the first paragraph and you want to read the last paragraph because oftentimes it'll just help you figure out what the hell's going on and where we're at in land. Now you're probably all looking at this and you're like, what the hell is a non-suit? What is a directed verdict? What the hell is a sumsit? Right? You're like, I have actually no idea what's happening. Right? So essentially a directed verdict is saying like the court decides that like this that the facts and the rule of law show that like X is true, right? That like the defendants or the plaintiffs should win. So that's what they're essentially saying here is that it was denied, saying that okay. And what we're going to find out here when we scroll down to the bottom of this particular case is that a new trial is ordered, meaning that they have to go back and try this case again because the plaintiff's motions or the defendant's motions were not correct. They weren't, um, they should have been denied. So let me come back up to the top. Okay. The defendant seasonably moved to set aside the verdict upon the grounds that one, contrary to evidence, uh, against the weight of the evidence, against the weight of the law and evidence, and because the damages awarded by the jury were excessive. The court denied the motion upon the first three grounds, but found that the damages were excessive and made an order that the verdict be set aside unless plaintiff elected to remit all in excess of $500. The plaintiff having refused to remit, the verdict was set aside as excessive and against the weight of evidence, and the plaintiff accepted. Um, so essentially, right, as we're reading this, this gives us an overview of what the hell happened, but we're still probably extremely lost, right? I remember reading these paragraphs when I first started law school, and I was like, I have no idea what the fuck is going on. That's normal. That's okay. What I would recommend doing when you're reading a paragraph like this is plug some of these words into Google, into some sort of AI program, and be like, give me an explanation as to what this means. Doing this at the beginning will be so time intensive, but it will help you so much. You will get so much faster at reading as you get through the semester because you'll understand what these weird words mean, right? And essentially, what this is saying, right, is that defendants were upset with the outcome of the trial. Therefore, right, they asked for these remedies to exist. And now this has been appealed all the way up to the Supreme Court. Does anyone have any questions based off that? Okay. Okay, so let's read this next paragraph. So the operation in question consisted the removal of a considerable quantity of scar tissue from the palm of plaintiff's right hand and the grafting of skin taken from the plaintiff's chest in place thereof. Okay, so this is a helpful fact, right? The question that they were talking about, oh my God. Guys, I thought I'm not used to highlighting in this. I thought that it would like highlight the whole thing. Um, wow, this is just embarrassing. Okay, hang on. So this is like an important part of the question that I would, or the part important part of the facts that I would talk about, right? So I'm gonna come over to my brief and I'm gonna put a bullet point and I'm gonna say, plaintiff had removal of scar tissue from right hand and grafted skin from chest. The scar tissue was a result of a severe burn caused by the contact with an electric wire, which the plaintiff received about 9 years before the operation and the transactions here occurred. When I see the word transaction, right, that's going to trigger for me that this is probably something to do with a contract. Um, so we're going to keep going. There was evidence to the effect that before the operation was performed, the plaintiff and his father went to the defendant's office, and the defendant, in answer to the question, "How long will the boy be in the hospital?" replied, 3 or 4 days, not over four. Then the boy can go home, and it will just be a few days when he will go back to work with a good hand. Clearly, this and other testimony to the same effect would not justify a finding that the doctor contracted to complete the hospital treatment in 3 or 4 days, or that plaintiff would be able to go back to work within a few days thereafter. The above statement could only be construed as expression of opinion or prediction as to the probable duration of the treatment and plaintiff's resulting disability, and the fact that these estimates were exceeded would impose no contractual liability upon the defendant. Okay, so this part that I've highlighted here in purple, I would put in the analysis section. And one of the reasons I would put it in the analysis section is because it's giving us. Usually, when you are seeing a sentence that's very, very specific to the facts, that's going to fall more into an analysis than into a rule sentence. Now, what we can say is that the fact that these estimates were exceeded and could impose no contractual liability upon the defendant, that portion very easily could be construed or put into a rule sentence, but likely we would put this more in the analysis. Also, keep in mind that the analysis is essentially explaining why the rule is the way that it is. Does that make sense? So, of course, it's going to talk about things that are very similar to the rule, which is why sometimes that can be confusing. Also, I'm realizing over here that I put this incorrectly. You can put it in whatever order you want. I just prefer to put the issue first. Okay. The above statements could only be construed. Were exceeded, would impose no contractual liability. Oh, geez. Upon the defendant. Okay, we're going to keep reading. The only substantial basis for plaintiff's claim is the testimony that the defendant also said before the operation was decided upon, "I will guarantee to make the hand 100% perfect, a 100% perfect hand, or 100% good hand." It's a weird sentence, but once again, this is from 1928, so we can't expect it to make a lot of sense. The plaintiff was present when these words were alleged to have been spoken, and if they were to be taken at their face value, it seems that proof of their utterance would establish giving a warranty in accordance with his contention. Okay, we're gonna just keep reading. The defendant argues, however, that even if these words were uttered to him, no reasonable man would understand that these were used with the intention of entering into any contractual relation whatever, and that they could reasonably be understood only as his expression in strong language that he believed the expected uh that as a result of the operation, he would give the plaintiff a very good hand. It may be conceded, as the defendant contends, that before the question of making a contract should be submitted to the jury, there is a preliminary question of law for the trial court to pass upon. Whether the words could possibly have the meaning imputed to them by the party who founds his case upon a certain interpretation. But it cannot be held that the trial court decided that this question erroneously in the present case. It is unnecessary to determine at this time whether the argument of the defendant based upon common knowledge of the uncertainty which attends to all surgical operations and the improbability that a surgeon would ever contract to make a demand part of the human body 100% perfect would, in the absence of countervailing considerations, be regarded as conclusive, for there were other factors in the case present which tended to support the contention of the plaintiff. There was evidence that the defendant repeatedly solicited from plaintiff's father the opportunity to perform this operation, and the theory was advanced by plaintiff's counsel in cross-examination of defendant that he saw an opportunity to experiment on skin grafting, in which he had had little experience. If the jury accepted this part of the plaintiff's contention, there would be a reasonable basis for further conclusion that if defendant spoke the words attributed to him, he did so with the intention that they should be accepted at their face value as an inducement for the granting of consent to the operation by the plaintiff and his father, and there were ample evidence that they were so accepted by them. The question of making of the alleged contract was properly submitted to the jury. Okay, that was a lot of jibber jabbering on my part. So, we see here, right, this buzzword of okay, let me find it. Whether is going to oftentimes lead you to what the issue is, right? And so this, oh my goodness, guys, this is atrocious. Let me delete this. Hang on. What we're seeing here, right, is that this is going to end up being our issue statement. Jesus, this highlighting situation is a nightmare. Um, which I think is super helpful for us to have an understanding of. When you see the word whether, oftentimes that is triggering and leading you to the issue statement. When you see the issue is whether, that is also going to lead you to the issue statement. Yes. So essentially what we did here, right, is for the issue, we basically consolidated what this paragraph is saying. And what we're trying to realize is the issue is whether the conversation that occurred between plaintiff and defendant constitutes a contract, right? And at the end of the day, I think that's a super helpful being able to put an issue statement into your own words is something that I think is really undervalued because it will allow you to have a better understanding of what the hell is going on. Okay. Let's keep chugging along. So, the substance of the charge to the jury on the question of damages appears in the following question. If you find the plaintiff entitled to anything, he is entitled to recover for what pain and suffering uh, he has been made to endure and for what injury he has sustained over and above the injury he had before. So oftentimes they will tell you whatever the question was that they gave to the jury, right? And that's not to say that the question they gave to the jury isn't a helpful question, right? But it is something where you want to consider, is this actually the crux of the issue that they're trying to show me in this case, right? So then what you're going to see is to this instruction, the defendant seasonably accepted. By it, the jury was permitted to consider two elements, pain and suffering, and the positive ill effects of the operation. Authority for any specific rule of damages in cases of this seemed to be lacking, but when tested by general principle and analogy, it appears that the foregoing instructions were erroneous. So, by damages as a term that is used in the law of contracts is intended for compensation of breach. When you start to see them citing to other things, like we are here, that generally means that we're heading into what's going to ultimately be more of the rules section of the case, right? And when you see them doing something like the present case is closely analogous to one in which a machine is built for a certain purpose and warranted to do certain work, when you start to see the words analogous or when you see the words contrast, right? Those both are very solid indications that that means we're showing a comparison and contrast to what has previously been the ruling or the law of the land in a specific jurisdiction. The rule thus applied is well settled as in this state. As a general rule, the measure of a vendee's damages is the difference between the value of goods as they would have been if the warranty as to quality had been true and the actual value at the time of sale, yada 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 yada. So what we're seeing here, right, is that at the end of the day, there is a question, like we talked about over here, of whether the conversation constituted a contract, right? But I think what we're recognizing as we continue to read through the rest of this case is we start to realize that the issue may in fact be a bit more specific, a bit more niche, because this rule that we're talking about here is ultimately going to be the rule that we're going to pull from this case and is going to be the thing that we use moving forward, right? And so I do think that this issue statement is strong, right? I do think that based off the information we had when we talked about the issue statement, it's accurate, right? But there is a more specific issue statement that I think will ultimately come back to redraft. Did someone say something? No? Okay. How about we just go ahead and we're going to finish reading the case and then we'll go back to finishing our brief. The extent of the plaintiff's suffering does not measure this difference in value. The pain necessarily incident to a serious surgical operation was part of the contribution which the plaintiff was willing to make of his joint undertaking with the defendant to produce a good hand. It was a legal detriment suffered by him, which constituted a part of the consideration given by him for the contract. It represented a part of the price which he was willing to pay for a good hand, but it furnished no test of the value of the good hand or the difference between the value of the hand which the defendant promised and the one which resulted from the operation. It was also erroneous and misleading to submit to the jury as a separate element of the damages any change for the worse in condition of plaintiff's hand resulting from the operation, although this error was probably more prejudicial to the plaintiff than to the defendant. Any such ill effect of the operation would be included under the true rule of damages set forth above. But damages might properly be assessed for the defendant's failure to improve the condition of the hand, even if there was no evidence that its condition made worse as a result of the operation. It must be assumed at the trial court, in setting aside the verdict, undertook to apply the same rule of damages, which he had previously given to the jury. And since this rule was erroneous, it is unnecessary for us to consider whether there was any evidence to justify his finding that all damages awarded by the jury above $500 were excessive. Defendant's requests for instructions were loosely drawn and properly denied. A considerable number of issues of fact were raised by the evidence, and it would have been extremely misleading to instruct the jury in accordance with the defendant's request number two, that the only issue on which you have to pass is whether or not there is a special contract between plaintiff and defendant to produce a perfect hand. Equally inaccurate, the defendant's request number five, which reads as, you would have to find in order to hold the defendant liable in this case that Dr. McGee and the plaintiff both understood that the doctor was guaranteeing a perfect result from the operation. If the defendant said that he would guarantee a perfect result and plaintiff relied on that promise, any mental reservations which he may have are immaterial. The standard by which his conduct is to be judged is not internal, but external. Defendant's request number seven was as follows. If you should get so far as to find that there was special contract guaranteeing a perfect result, you would still have to find for the defendant unless you found that the further of the operation would not correct the disability claimed by plaintiff. In view of the testimony that the defendant had refused to perform any further operation, it would clearly have been erroneous to give this instruction. The evidence would have justified a verdict for an amount sufficient to cover the cost of an operation, even if the theory underlying this request were correct. Okay. That was a lot of information that we just ran through. So what we're going to do is we're going to come back up here and I'm going to pause the recording again. Okay, so essentially what we did here, right, is we copied this rule statement from this purple section. And the based off that, right, we want to come back up here and we want to talk about what the issue statement is. We talked about how this is a really strong issue statement, but it doesn't get to the specifics of what this case is focusing on. And so I would probably say the issue is the issue is what measure of damages are applied when someone breaches a contractual promise regarding the quality of a service. So one of the things that you'll learn about in contracts is there are two different types of contracts. There are service contracts, and then there are contracts for services, and there are contracts for goods. Services, think like I'm hiring someone to paint my house. I'm hiring a surgeon to fix my hand. Goods, think of like I'm selling a pair of Crocs, right? Those then are governed by different types of law, and we're not going to get super in the weeds, but that's why the term service here is really important because it's indicating to us that we're talking about the common law versus the UCC. Okay. And right, this also pairs nicely with our. Oh, yes. Okay. Bye, Riley. Um, this will pair nicely, right, with our rules statement. And our rules statement that we're attempting to focus on here, right, is essentially this idea that the measure of damages is the difference between the value of the goods that would have been the warranty as quality had been true and the actual damage at the time of the sale, right? But as we're reading this, we're realizing this might be talking about the UCC because we're talking about goods. So we therefore conclude, yada, yada, yada. Okay. So, right, this is where we come down to here and we see more of the reasoning. The pain necessarily incident to a serious surgical operation was part of the contribution which the plaintiff was willing to enter, right? It was a legal detriment suffered by him which constituted a part of the consideration given by him for the contract. It represented a part of the price which he was willing to pay for the good hand. It furnished no test of value of the good hand or the difference, right? So they're contrasting what we found in this general rule as it pertains to goods. And part of the reason they're contrasting it is because this is talking about a service, whereas the case law that we have here is talking about a good. Okay, so we keep going. Any such ill effect of an operation would be included under the true rule of damages set forth above, but damages might properly be assessed for the defendant's failure to improve the condition of the hand, even if there was no evidence. Okay. So let me cross this out. I don't even know how to do that. Okay. So essentially what we're going to find here, right, is that when someone is making a contract, right, they express that they want to enter into a contract, they are liable for the difference between what they promised and what the result was, right? We are talking about the benefit of whatever they were expecting. And this is called an expectation damage. An expectation damage is a specific type of damage that an individual has available to them when they enter into a contract. And so essentially what we're figuring out between this paragraph here, I already have this the right color. What we're essentially seeing from this part of the case mixed with this part above, right? And looking that there was evidence to justify his finding that all damages awarded above $500 were excessive, right? We're seeing that there is nuance to this, right? Because essentially what we want to find is that we're putting together two different rule statements. And this is where I do think that rules statements can get really complicated, which is part of the reason why I wanted to pick this case. There will be situations and cases, and oftentimes the cases that you will read the first week or two of class will be so straightforward, where it's like the rule statement you will literally copy and paste. Other cases are a little bit more abstract, especially with contract cases. Contract cases get complicated, which is part of the reason why I selected this. That is why a lot of schools actually do contracts in the second semester because you have a little bit more time to get things under your belt to have an understanding of what the hell is going on. So the rule here, I'm going to try to make it as simple as possible. When an individual makes an express contractual promise regarding a specific result, they are liable for the difference between what was promised and what was delivered. Which makes sense, right? Because if I promise to someone I'm going to give you X, right, and I actually give them Y, right, then and that person, suffers some sort of detriment because of that, it makes sense that I would then be liable to give them the difference between what they signed up for, and what they actually got in return for that. Okay, so right for the conclusion, we are essentially going to come down here and we're going to see that there was a new trial ordered, right? And so the conclusion is essentially that the court ordered a new trial, and usually you want to incorporate like some sort of a because, right? You want to incorporate some sort of like, okay, why did the court order a new trial? And it's because, right, um, it is unnecessary to consider whether there was any evidence to justify his finding that all damages awarded by the jury above 500 were excessive. Okay, so we're seeing that, and then we're going to scroll down here. And the evidence would have justified a verdict for an amount sufficient to cover the cost of such an operation, even if the theory underlying this request were correct. So we would probably want to say the court ordered a new trial because the damages allowed to the plaintiff would be expectation damages, which is not what the court previously permitted in the underlying case. Okay, so this is what our case brief is going to look like. Oh, I forgot to fill out the facts. Plaintiff had removal of scar tissue from the right hand and grafted to the skin to the chest. The doctor promised that the individual would have complete function of their hand. The individual is still suffering from the injury they suffered prior to the surgery by the doctor. This will be our case brief, right? And normally when I am putting this in my notes, right, I will basically put up at the very top, if I can get this to freaking work. I'll put the case name up at the top of it. So I would basically go like italicize. I would say Hawkins v. McGee. Then I would say NH Supreme Court. Sometimes your professors will ask where the case is from and what year it's from, and I would still probably put 1928, 29. And then you can also say, if it's from your textbook, I recommend putting like page X through XXX. That way you'll be able to find it when you go back to review these cases, when you're making your outline, when you're preparing for finals, when you're going through notes, all of those types of things. Um, but yes, let me do this. Then when I'm preparing this for class, right, I normally would just have like July 30th, 2026. And I would say, contracts, class preparation, July. That's basically what I would do. And then from there, I would then go under here, I would add italics again, and then I would add in my subsequent case briefs based on what other things I needed to read for class.